Thank you very much. Good morning, ladies and gentlemen. I have an interesting topic to speak on, and I understand that we have a short duration speech. It's about 20 minutes to half an hour. I don't know if there are questions at the end, but that'll depend on how things go. It's a great honor to be speaking here in the presence of Lalit Bhai, because I've, in my own life as a lawyer and otherwise, I have grown up in the shadows of people like him, and therefore it's wonderful to be speaking to you on this occasion. Now, it's interesting that when I arrived in this hall, there was a panel discussion and there were 4 chairs. Understandably, those chairs are gone, and there's just 1 chair now. And the discussion that was happening was discussion on artificial intelligence. And I think that's a cutting-edge technology matter which everybody would have been absolutely riveted to. People who were here were outstanding experts in the field. And I believe that this is the greatest challenge of our generation and our times. But what I am going to say to you, I will try in some ways to link with whatever perceptions you have possibly on artificial intelligence. There are 2 ways to deal with literature and law. One is that there are compilations, people have collected various literary anecdotes relating to judges or lawyers and to legal arguments. There are other collections where judges who have recited couplets from various places, various languages, particularly so in India, that they have collected those. So just repeating whatever is available in the book form would not be, I understand, would not be as productive and as instructive as something that I'm trying to be able to do, which is less concentrating on content of literature in law. And we know that you can go back to law through great writers like Charles Dickens. You can go through law in various literature that we have seen from different countries like Russia, Europe, United States of America. But I am just going to request you to try and focus on something that is very critical. And that is about looking at law and understanding law in terms of literature. So whatever somebody puts into a judgment, an exciting couplet from Ghalib or an exciting couplet from Shakespeare or an inciting passage from some top novelist, etc., has a meaning. It makes the reading of that judgment a little more attractive. It makes the point a little pithy. It points to something that the judge is trying to say, and therefore helps you concentrate on that particular factor. But I'm not sure that any judge or any appellate court has ever said that I disagree with the use of this particular couplet in this particular judgment. I'm not sure that we've ever come across any such appellate court saying that I disagree because this couplet gives the wrong meaning to what the law is, etc., etc. I am therefore putting to you a proposition that law is like literature. Law is like literature, and I will amplify that particular proposition as to why law is like literature. Very quickly, we don't have the time for this, and perhaps another moment, another time we can do some further elaboration of this topic. But very quickly, and since many of you are law students, many of you are distinguished lawyers, and you have an understanding of what happens in the legal system, let's ask ourselves very quickly, what is law? what is law. Some people think it's so easy to understand what is law. We all know what is law. That you don't park your car on the pavement, that's law. That you don't hit somebody, you don't abuse somebody, that is law. Because these are commonly known areas of law. We all understand. But if you go a little bit further and say, why is this the law? The answer then, if you reflect upon it, is to say because Parliament made it, and that's how it's law. So anything that Parliament drafts, legislates, votes upon, and which then is approved by the President of India, whatever the processes and procedures are, and then is notified in the Gazette of India, is the law. And it gives the date from which it applies, and which areas of the country it applies to. So that's the law, and that's easily understood. That's not a problem. The problem arises for judges because judges like us apply the law just in that manner when the law is, the case before them is a simple case. I hit somebody without provocation. I had no reason to hit somebody. When I get before a judge, the judge says, you did wrong, you should not have hit. You know that you cannot just hit people. You didn't do it in self-defense. The law is very clear, therefore you must be, and sanction must be imposed upon you. You either give a fine, or you make amends for what you have done, you apologize, or you pay some money to him for the loss that you have caused to him, etc., etc. Those are simple cases. And simple cases is not the test really of law. The test of law is in what is called a hard case. And you know, we know the adage. We know the adage that hard cases make bad law. Why do people say hard cases make bad law? Because hard cases begin as hard cases and remain hard cases even after the judgment comes quite often. Sometimes the judgment clarifies and makes sure the hard case is no longer a hard case. But sometimes, despite the judgment, you continue to think, no, that judgment is completely wrong. The judge didn't understand what I was trying to say. This is too difficult a case. This is too hard a case. And I give you an example. Some of you, obviously, some of you were not born then. Some of you would have been very small. During the emergency in India, during the emergency, there was a famous case of habeas corpus. And it came before a very large constitutional bench. Justice Chandrachud, who then became Chief Justice, was one of the judges, and Justice Bhagwati was another one of those judges. Justice H.R. Khanna gave that remarkable dissenting judgment. And what was the proposition? The proposition there was, because habeas corpus is dependent on a constitutional provision, if the constitutional provision is suspended, does the habeas corpus also get suspended? And the majority said, it's so obvious, it will be suspended. Only one judge said, no, it cannot be suspended, and he had some reasons that he had given, which are remarkable reasons. 25 years after that judgment, 25 years after that judgment, another bench of the Supreme Court overrules it. And in that bench is who? The younger Chandrachud, Justice Chandrachud, is on that bench. He overrules his father 25 years later, and says that is wrong. Now, why is it wrong? Let's find the basis of his saying that that was wrong. And that's Puttaswamy's judgment, 9 judges. 9 judges could overrule 5, obviously. And he says, and please go back and study this a little carefully, he says that there are rights that precede the Constitution. So the right to liberty, right to dignity, and other areas of fundamental rights exist even before the Constitution. Call them natural rights, call them rights of the original compact between society and social contract and so on that Rousseau had. But ultimately, these rights are there before the Constitution. The Constitution merely enumerates those rights. These rights exist before the Constitution, so if you suspend the Constitution, the rights will not go. That's a remarkable, marvelous judgment, and I think that the 9 judges have to be greatly applauded for it. This has now become simple. What was a very hard case when the ADM Jabalpur was decided, what was a hard case, despite 4 judges having said you can suspend habeas corpus, 1 judge having said you cannot suspend habeas corpus, it remained a controversial judgment. Despite those judges, 2 of those judges having become Chief Justices of India and very successful Chief Justices, for 25 years we were all uncomfortable with this judgment. So ADM Jabalpur did not turn a hard case into a easy case, a simple case. It remained a hard case, and now perhaps we can say that that hard case ceases to be a hard case after the Puttaswamy judgment, in which that case has been overruled. There's no controversy about Puttaswamy unless there is some kind of a purist who wants to raise a controversy about Puttaswamy, but I think that there is no controversy about Puttaswamy, so that's become simpler. It's now being followed in other judgments. Now, when you have a judgment like Puttaswamy, and when you have a judge like younger Chief Justice Chandrachud, who became Chief Justice, what is it that tells us about the making of law? Is the making of law a simple thing like making of a law by legislation, or is the making of law very different from legislation? So whatever had happened in ADM Jabalpur could have been reversed by Parliament. Parliament could have passed a constitutional amendment and reversed it, but it didn't. It continued to hold that firm. But it was a court that reversed it. But when a court reverses something, changes the law, is the court saying, from henceforth this will be the law? When Parliament passes something, it says, from today, from this date, this is going to be the law. But when the judge does it, when the court does it, they don't say that this will be the law henceforth. Prospective, overruling, etc., etc. I can understand those are finer points. But they are essentially saying the law has always been what we are now saying is the law. So if you ask the younger Justice Chandrachud, are you saying that for 25 years that was the correct view, and 25 years later that has become a wrong view? He would have to say that that view was never a correct view. We only treated it as a correct view because that is the manner in which we function as lawyers, and that's the manner in which we function as courts. So when the new judgment is given, the 9 judges judgment is given, is it simply the same thing that Parliament would have done, or is it different from Parliament? This is where I come to the topic. My proposition to you is that this is different from Parliament. Parliament just says, what was I voted for? What is good for society? What will help me get re-elected? Why don't I do this? And then I'll get the maximum amount of approval from the people of the country, etc. So Parliament does it in that manner. A judge never does this. Judge never says, will the people approve it? The judge doesn't say, will I become popular? Will I be elected to be a judge again? He doesn't do all that. He just simply says, my job is to find what the law is. And if you show him something, he says, prima facie, yes, this is the law. But if he disagrees with it, and if he disagrees with it, he says, no, this is a mistake, this is wrong, I'm going to overrule it. It's very different from Parliament. So what does he do? What does he do? He has to do what is something called interpretation. What is interpretation? What is interpretation? Parliament simply has to choose, the judge has to interpret. So interpretation is something that is added to the process of decision making when you are a judge. And that interpretation involves many things. That interpretation involves the search of the true values of your society. So you know the Constitution, people often talk about constitutional morality. What is constitutional morality? If everybody knew what is constitutional morality, these judgments would not be there. And there are several judgments talking about constitutional morality. So you look at the Constitution as a whole, and you look at different segments of the Constitution or different provisions of the Constitution, you try to marry them together as the directive principles and fundamental rights were married together in series of cases. And Justice Bhagwati, Justice Krishna Iyer, etc., married them together because the general impression had been that fundamental rights override directive principles. Directive principles are not some things that can be enforced, but this was then changed into a proposition that directive principles inform what are fundamental rights. You have to read the two in harmony and read them together. But the point remains that when you go and look at the Constitution, every element of the Constitution is not apparent. You have to look at different elements, marry them together, and then arrive at what is the true value or true meaning of the Constitution. And this is what is called interpretation. Interpretation is the normal statutory interpretation. There are rules given to you as to how you will judge what the statute means, etc., etc. There is a purposive interpretation. There is a mischief rule in interpretation. There is the original intent rule in interpretation, etc. But interpretation in a larger way, as the judge applies interpretation philosophically, is something different, and it is akin to searching the true value which is embedded in the Constitution. When you look at the Constitution as a whole, you can say something and say, this is a Constitution we must follow. But what is it in the Constitution that you must follow? The challenges today in our society is, when society thinks differently and separately, what do? When you introduce Uniform Civil Code, you say we are pursuing Article 44 of the directive principles of state policy, which says that there must be one civil law for everybody in this country. But the moment you say that there should be one civil law for everybody in this country, somebody else opens the chapter of fundamental rights and says, but everybody in our Constitution has a right to follow their own religion. So how would you balance the right to follow your own religion with the direction on the fundamental directive principles saying that everybody must have the same law? This is something that jurisprudence will have to decide in future. So what you need is interpretation. Interpretation, how will you balance it? How will you have one having more weight, one having less weight? And that interpretation process is what an outstanding jurist, name of Ronald Dworkin, has done when he says that looking at law involves interpretation. And that interpretation means that you look at the entire history, you look at everything that is provided in history, you look at all the decisions, you marry them and see how from different subject on different aspect the decisions are different, and then find the true essence of what your society believes in. Then he says, how is this done by a judge? And that's where I come to the topic of law and literature. He says the judge does it like a chain novel. Now, you know what a novel is? When you're writing a novel, you're the author of the novel, you have a large picture, you have a plot in mind, you have some characters in mind, and then you start writing a novel, you have the plot, you play the plot, you see how each person operates, how people interact, and sometimes the novel gets a life of its own. You start writing a novel hoping to do something and you end up doing something else. But the broad aspects, the broad thematic dimensions remain the same, because you are one author, you have in mind that you're writing a novel about something. And so you start with the first chapter, one author in the first chapter writes the first chapter, then the second author is asked to write the second chapter. Now the first author has laid out the lay of the land, as it were. The second author has to respect it and build upon that. So he can't reach completely different theme. He has to have a similar theme and he will follow that theme. Similarly the third author, similarly the fourth author. So the chain novel then develops, because there is something that remains in common between the first author and the tenth author, and yet the first author doesn't know everything that he has to do, because he writes only one chapter. And the 10th author can't just write anything he likes or she likes, because they will be influenced by the first 9 chapters. So it has to be within constraints of the first 9 chapters, some freedom available to the 10th author, but he's conscious that I can't go beyond the 9 authors, etc. So this is how legal interpretation works. Very much like literature. Very much like, because the judges change after one judge, the next judge who comes reads the chapter written by the first judge, the judgment written by the first judge. Now sometimes he will continue along that path, but suddenly one author will say, no, this is wrong, as Justice Chandrachud, the younger one, said about Justice Chandrachud, the elder one, that this is wrong. So it's only after 10 chapters have been written that he says, sorry, what you think was written in the first chapter is wrong. It was not there. It's a mistake. And therefore, my chapter will explain how that was a mistake. And we will now give you the final end of the story. And the end of the story will be quite different from the beginning of the story. But it is not a freewheeling end of the story, that I don't read the first 9 chapters, I will write a chapter afresh. That's not what it is. You are bound in some ways by what has gone before as the first author, and you are therefore in some way linked with what that person has done. Finally, when you do what you are doing. Now there the word integrity comes in. What you have to be conscious of is a little more than consistency. Consistency is just some commonality. Integrity is when you appeal to something fundamental and basic inside. You can have a different approach as long as there is integrity with the approach that started off in the beginning. And that's how law is like a chain novel. And that's how judges can remain consistent with what has happened before and yet have the freedom to move and do something new. Now, when Justice Chandrachud the Younger said that mistake was made about the habeas corpus judgment, how did he say it? Not just out of instinct, not just out of freewheeling desire for greater freedom, but because he read all the systems, all the judgments, and he says that in all the judgments of this country, our theme is different. Our theme is more freedom, not less freedom. And what ADM Jabalpur does is less freedom rather than more freedom. And therefore, I have to treat that as a mistake, and I have to go back to the track that I should follow, the track that I should follow. And that's how he moves. Now, Dworkin says, somebody who has to do all this, that judge I will call Hercules. This is not the task for an ordinary person. This is a task for an extraordinary, larger-than-life human being, and therefore I will call him Hercules. Hercules is the one who can find all these solutions, because Hercules is the one who can reach out to the millennia, who can reach out to the entire history, who can know all the judgments, who can analyze all those judgments, and then finally come to a conclusion for which he can be applauded to say, now this is a good judgment. But of course, this leaves it open. If you write more chapters, it leaves it open for you to write a chapter by which you could say, this is also a mistake. That what has happened in Puttaswamy is a mistake, but very unlikely, because if you read and look at the strands of Puttaswamy, it matches with our general philosophical beliefs as Indians. So, dignity that we believe in, right, equality we believe in, autonomy of choice we believe in, freedom and liberty we believe in. So it's highly unlikely that this could be written into another chapter by which they will say that Puttaswamy was wrongly decided, just as ADM Jabalpur was said to be wrongly decided. So literature has a big story to tell us about how judges decide cases and how they ought to decide cases. Many of these things, I think, will be contested in courts in times to come, and we'll have to see how the courts deal with it when these challenging, divisive, and conflicting opinions about human race and about how we citizens treat ourselves and our systems come before courts. And then maybe we'll have another chance to discuss what the end chapters will do. Thank you very much, ladies and gentlemen. Do you have any questions?
It's not a question, it's an observation based on a very famous couplet of Mirza Ghalib about the dissenting judgment, you know. He said, Ya Rab, na wo samjhe hai na samjhenge meri baat, de aur dil unko jo na de mujhko zuban aur. That is the dissent part of it, you see.
तो मेरी जुबान आप समझ गए ना?
बिल्कुल समझ गए.
Dinesh from Panipat. Sir, I want to know that when it is very clear that for a citizen who is seeking his fundamental rights for justice, means when the whole administration, the whole police system of the state is hell-bent to kill his justice very systematically, means suppressing the evidences and very clearly, protecting the accused, then what's the right course for the citizen when his justice is being killed totally by the police system?
I can understand it. I can understand that in the prevailing system, in any government, in any system, in any country, there are ways of looking at things that there can be disagreement. Between the ruling party and the opposition, there can be disagreement. Between those who have opted out of elections, there may be a disagreement. Between ordinary people, there could be a disagreement. People sitting here could disagree on something. But that's why we have faith in the courts being able to solve this problem for us. When there is disagreement, how do you resolve a disagreement is the responsibility given to courts. And therefore, I believe that we should, no matter which party is in power, that party must ensure that they give the most consideration to what the judges decide. We should have the most outstanding judges to begin with, and we should do nothing to influence the decision-making powers of the judges. Let them decide. They can make a mistake. Anyone can be wrong. Human beings can make a mistake. But we should trust them, and we should believe in them, and we should have faith, because there is no better system than the system of judges to find some relief for whatever we want. Somebody who can adjudicate, somebody who can mediate, somebody who can find common ground between disagreeing parties. There you go. I'm a judge-oriented person.
Hello, sir. Firstly, a great presentation. I loved it absolutely and learned a lot. My question to you is, since from your experience and practicing for so many years, what is the most important point when you're trying to persuade a judge? What is the one thing of paramount importance that a young lawyer or an experienced one needs to remember when he's trying to persuade a judge?
Well, I see the first thing you have to understand about a judge is what appeals to him. I'm not saying that you be sycophantic to a judge, but every person has some likes and dislikes, some preferences, some non-preferences. Make sure whenever you persuade a judge, you persuade it in a manner which is neither sycophantic, nor submissive, nor completely aggressive against the judge. Take the judge along the path that he is familiar with or she is familiar with, and then from that path show the road that you want to take. Thank you. Yeah.
Sir, I am Muhammad Yasir and I am from Aligarh Muslim University. I want to ask something from you, sir. As you said that in emergency fundamental rights also exist, but there are some persons who are confined from the UPA and the judges are not granting them bail, whether the judges are in fear of the government or they are not capable of giving it.
Are not given bail?
Sir.
Listen, this is this huge conversation amongst judges about when bail should be given, when bail should not be given. It's a contest between governments whichever government, trying to restrict the openings for bail by making laws in which they say bail can't be given if you are a UAPA accused, then bail can't be given. But you have seen how Supreme Court wonderfully has got around and said the statute may say bail can't be given, but Article 21 says bail should be given. And therefore, Article 21, which is a constitutional right, will prevail over what the statute says. So they find the balance. And whatever I try to describe to you, I think is reflective of that balance that the Supreme Court tries to find. Sometimes they go wrong in the balance, but quite often they do this remarkable thing that when you read the text of the statute, it says no bail. And then the Supreme Court suddenly says, but Article 21, because there has been conduct of the police that requires Article 21 to prevail, because there has been delay in trial, requires Article 21 to prevail, and therefore bail should be granted. So ultimately, the Constitution is the repository of our true values and faith, much beyond any statute. Now, they've not struck down any statute, because they've said the statute is a necessity. Let's have it because these are difficult times and so on. The governments also have to ensure that there is proper governance. But at the end of the day, the Constitution will prevail. Thank you.